Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss legal victories and challenges to your fundamental freedom and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, founder and chairman of Liberty Counsel, explains the latest legal issues all across this country. In the courtrooms of America, Liberty Counsel is winning the battle for your constitutional freedom.
Our Obamacare case is still alive and well. The Supreme Court issues a decision on this particular issue, directing the government to respond within 30 days. I am Matt Staver, founder and chairman of Liberty Counsel. Joining me is Matt Barber, vice president of Liberty Counsel Action. Matt, our case, Liberty University versus Geithner, in which Liberty Counsel represents Liberty University and two private individuals challenging Obamacare, the first private lawsuit filed in the country on the very day this was signed into law, is now still alive and well. The Supreme Court just recently directed the federal government to respond to our petition for rehearing. They have 30 days in which to do this. Once they do that, we'll file a reply, and the Supreme Court will make a decision whether to send this case back to the Federal Court of Appeals, which will put us back on a fast track to not only get our decision at that level, but then from there ultimately go back to the U.S. Supreme Court.
Yeah, this is really exciting after the decision in June coming out of the Supreme Court, where, of course, Chief Justice Roberts kind of shocked everyone and siding with what we thought would have been the minority. There's new life breathed into the court challenges on Obamacare. It seemed for a while that the last possible hope in order to do away with this monstrosity was in the legislature, which is still a distinct possibility, and that's a lot of that will play out in the election. But it's exciting to see that our case may yet make it to the Supreme Court and be ruled on the merits.
Well, a lot of media took up a lot of different articles, and it was front news in many of the news outlets a few days ago, and some pundits were talking about how this may actually open up the door for a new challenge to Obamacare. Now, in our lawsuit that we filed back in 2010, we challenged the individual and the employer mandate, which made it unique because we challenged both mandates, not just individual but also employer mandate. And we also challenged what had been argued before the Supreme Court, namely that Congress lacks the authority to pass this law. But beyond that, since we were private individuals and not the state, we were able to raise the free exercise of religion claim, saying that Obamacare, even if it could be possibly conceived as authorized, which I still don't believe it is by the Constitution, it violates another constitutional provision, namely the free exercise of religion, by forcing individuals and particularly employers to fund abortion. So when our case was pending at the Fourth Circuit Court of Appeals in Richmond, Virginia, that court issued a decision not reaching the merits of the employer mandate or of the free exercise claim, instead ruled that the Anti-Injunction Act prohibited the court from reaching the merits because of the nature of that particular injunction. You had to first pay the tax and then ultimately ask for a refund before you could file suit. We petitioned that to the U.S. Supreme Court, and that became the very first day of the oral argument. Our case was what also ultimately was the first day of oral argument at the U.S. Supreme Court. And when the Supreme Court issued its ruling, it ultimately ruled that the Anti-Injunction Act does not apply, meaning that the court actually ruled in our favor on our petition. Well, what happened was when the Supreme Court issued its ruling in June, and then there were other cases there pending challenging also the individual mandate, it just simply denied all their petitions, including our case. We asked the U.S. Supreme Court to reconsider that, and it is absolutely unequivocally rare for the Supreme Court to revisit an order that it's already entered. But in this particular case, the court on the very first day back in session didn't deny our motion or petition for rehearing, but directed the federal government to respond to it, giving them 30 days. That sent shockwaves through the country because now it looks like our case will go back, I believe, to the Court of Appeals. We'll know within about 30 to 45 days what the Supreme Court will do. But I think the most logical thing is the Supreme Court grants our petition because we won on that petition, vacates or sets aside the Court of Appeals decision, sends it back to the Court of Appeals, and then we argue the merits of two issues that had not been argued before the court, and that is the employer mandate and the free exercise of religion.
And you mentioned that the media has latched onto this and has been reporting at Fox News, of course. I was reporting there are a number of objective, disinterested parties out there that are looking at this from the outside in, who are agreeing that that it's going to be hard for the federal government to shut this thing down, that there's a good chance that this could go back to the Fourth Circuit, all the way back to the Supreme Court. Former senior Justice Department official Thomas Dupree said that he thinks that we have, quote, very good arguments that we are entitled to our being Liberty Counsel and Liberty University, our day in court. I think he's right. This is, again, very exciting news.
I think so, too, and others as well. Politico, Fox, many other news outlets across the country, major media outlets, and then constitutional observers are saying that our case has a very good shot, because our case never did get the day in court, so to speak, because of the court saying that the Anti-Injunction Act applies, and that was their opinion, and therefore they couldn't reach the merits of the case. But the Supreme Court disagreed and said, no, it doesn't apply. And in fact, when we filed the petition, it was our case that had the Anti-Injunction Act in it, not the case from Florida. They didn't have that. The Court of Appeals did not rule on that particular matter against them. And so the Department of Justice, when our case was pending, said either our case could be separately argued on that issue, or you could require the other case that was clearly going to be there because the law was struck down, and that was a mandatory review, to include that in their arguments. And so that's what they did. Our case was the very first day of oral argument. And, of course, we won on that case. So consequently, they should grant our petition, send the case back down to the Court of Appeals, and then we argue the employer mandate, which was not decided or addressed, and also the free exercise of religion. Now, you've seen or heard about 30 cases in the country where people have filed the free exercise of religion against the Obamacare following the HHS mandate that requires forced abortion funding, contraception, and sterilization. But our case actually raised that back on March the 10th, 2010,
the day
when
Obamacare
this case
was signed.
was actually when the bill was signed into law.
Yeah, right. So we were the first. Now, people looking back to June need to understand the court only focused on the individual mandate aspect of it and the constitutionality of that. Somehow, with Chief Justice John Roberts, they decided that it was a tax, that this is a huge tax on the middle class and everyone else. So that aspect of it has been decided by the court. But there are two huge issues hanging out there. As you mentioned, the employer mandate, and the biggest of all, really, is the religious liberties issue. Obamacare tramples, even before the HHS mandate that you mentioned. Inherent within Obamacare is the carte blanche authority for the Health and Human Services Secretary, Kathleen Sebelius, a radical pro-abort, to essentially say that abortion is a fundamental necessary procedure, and she can just mandate arbitrarily that Obamacare cover it, taxpayer dollars cover it, and it does, in fact, cover abortion.
It does cover abortion. In fact, I was just reading The Amateur. I finished reading that, and this Ed Klein has done a lot of different personal interviews with people who had information in backroom discussions. And it appears that on this Obamacare HHS mandate, that Vice President Biden opposed it. And then the chief of staff that replaced Rahm Emanuel, Jim Daley from Chicago, also opposed it. But Valerie Jarrett, his closest advisor, supported it. So Jim Daley went around her, brought in then Bishop, now Cardinal Dolan, who actually told the president that this would violate free exercise of religion and rights of conscience. Despite that, Valerie Jarrett still insisted that this should be done because Roman Catholics that would be affected by it, and certainly other Protestants, they would just simply not care that much. And so President Obama authorized the mandate. Sebelius was in favor of it, and this HHS mandate came out. It is a direct collision with our religious free exercise, but we actually argued that a long time ago. And even before the HHS mandate came out, it was clear from Obamacare itself that it would be the largest funding of abortion, both for individuals and for the employers. And as it relates to Liberty University, that's simply a line that we cannot and will not cross. So this is alive and well. We'll continue to keep you updated with regards to the developments of this important case. And also, I encourage you to pray for Liberty Counsel while we're on this case, but not only this case, but we have many other cases around the country. Pray for the ministry of Liberty Counsel and help support us financially. You can do that by going to Liberty Counsel's website at lc.org. That's lc.org. You can sign up for the Liberty Alert email and also the Grassroots Action email. All of that's right on the front page. Also, go there to learn more about voter registration. Also about the candidates. We have voter guides that are C3 compliant for churches and other nonprofits. You can download those right there on the website and also help us to get information out to the churches. You can do that by contacting Liberty Counsel at lc.org and making a contribution so that we can get information to pastors and churches so they can speak biblical values and be unafraid this coming election cycle.
You have been listening to Faith and Freedom with Liberty Counsel. We hope that we have motivated you to stand up for your faith, family, and freedom. We can accomplish a lot when we work together. Get informed and get involved today. Sign up for our free monthly newsletter, The Liberator. We will send it out to you free of charge. Stay informed with our Liberty Alert email updates. Just click on the website at www.lc.org or call us at 1-800-671-1776. Tune in next time to learn more about your rights right here on Faith and Freedom.